That's the law. All
Okay,
right.
sir.
So
So, but
learn to live with it.
that's
Mhm.
that's a clear abuse of power. I've been up here for 150 days, and I've asked my clients, or not my clients, my attorneys, to please represent me in this matter, and they have not done it. And they can't give me a reason. They can't give me a KSA. They can't give me any of that. I've been up here for 150. This is an abusive process.
If you don't like it, go hire your own lawyer. Okay? That's your choice. Do
I'm
it.
not asking that. I'm not asking them to
No,
withdraw.
no,
I'm
I'm
asking you
done.
to rule
I
on the
am
procedural
denying the
timeline.
motion to withdraw,
Will you
and I
rule on the
appreciate.
procedural timeline error?
Okay. Jailer, put him on mute.
This whiny baby is in court today, and I promise you, he is one of the most annoying defendants you'll ever see. He completely disrespects his own attorneys, and the judge isn't letting it slide for a second. He's being accused of something absolutely unthinkable involving the loss of his 5-month-old daughter, and prosecutors also say harmful substances were found in her system, so now he's facing a very serious charge of second-degree murder. Let me know while we watch. Do you think this guy actually has a point? Or is the judge completely right to shut him down? Let's dive in and watch.
Your Honor, Mr. Leon appears by Zoom and through counsel, Christopher A. Rourke Colby and Cassie Ziegler of Ellis County.
All right, Mr. Leon, do you have any objection to us conducting this hearing by Zoom?
No.
Very good. At this before the court on the defense counsel's motions to withdraw. And those were recently filed as of actually yesterday, and both counsel asked for an emergency hearing or as early as possible. Mr. Leon, are you ready to proceed on your counsel's motions to withdraw?
I am, sir. And then I'd like to address the courts if that's okay.
Well, we'll see. Let's get to the motions first with the attorneys. Besides what's in the motion, is there anything additional that either attorney wants to present?
Your Honor, I think that the only thing, anything additional I present, I think given Mr. Leon's, I think, behavior, demands, threats, his actions going through with those threats, I think the trust between the attorney and client's broken, and I don't know how you fix that.
Okay. Ms. Ziegler, anything additional besides what Mr. Rohr said?
No, I totally agree with Mr. Rohr, and I don't think I have anything else, Your Honor.
Okay. Ms. Leon, I will now invite your comment. Leave it strictly to this motion to withdraw. Nothing else about the case, because that's not what's before us today. You understand?
Yes, sir. I do have, yes, sir. So,
okay. Regarding the motion to withdraw, do you wish for these two attorneys to withdraw?
So I have asked my attorneys to file a motion multiple times on a procedural timeline error of not having me into a preliminary hearing within 14 days. This right is guaranteed to me per the state statute 7-2 and supported by my 4th Amendment right to due process and incorporated by my 14th Amendment due process clause. State versus Fink does guarantee the defendant the right to be within a preliminary hearing within 14 days. And I've asked them both to file these motions. Neither one of them are filing these motions. And I would ask the court to consider these motions as well as, I mean, I haven't asked them to withdraw. They said I've just asked them simply to do something. Your Honor has already ruled on this and told me that he was not going to allow them to withdraw because of the state's short amount of attorneys that can handle these cases. So I have not asked them to withdraw at all. I've simply asked them to invoke and enforce my, or ask the courts to enforce my right to due process in my 14th Amendment due process clause because there is a procedural timeline error, and they continue to try to dissuade me from bringing this to your attention, saying that it's not correct. But I have the state statute pages right out of the book that an attorney has sent in that does guarantee me these, says that it does guarantee me the right. While it's not, preliminary is not, like mandated, it's not constitutional. But in that case, I would then need to be to an arraignment within 10 days. I've not waived that right. And my attorneys of counsel, my attorneys, I've brought this up to them multiple times. Cassie hung up on me once when I was trying to talk to her about it. Mr. Rohr has said that he was going to bring the issue up to you, and then next thing I know, he was telling me that the next thing I know, I'm getting a motion saying that you guys are going to withdraw. They're trying to withdraw counsel. I didn't ask them to withdraw. I took your ruling on the matter last time seriously, is that you were not going to let them withdraw. I'm not asking that they withdraw. I'm asking that they represent me to their fullest of capabilities in this matter of my the procedural timeline.
Okay.
Error.
So basically, this clown, who's in here for one of the worst cases you could imagine, is just reaching for anything he can grab onto. He's got two very capable attorneys sitting right next to him, and yet he acts like he's the only legal expert in the room. I mean, it's just laughable. And just the way he talks, you think he's been practicing law for decades. But my guess, he knows the mountain of evidence against him is massive, so he's just throwing every possible argument at the wall just to see if something sticks. I mean, that's what people do when they're desperate. But here's the thing, there's a difference between using a legal strategy and flat out ignoring the advice of the people who are literally trying to save you. I mean, he keeps stepping over his attorneys in court, which not only looks bad, but makes the judge less willing to hear him out too. Public defenders aren't perfect, but they know the system better than 99% of defendants. The more he argues, the more obvious it becomes. He's either in full denial, or he actually believes he's smarter than the people trained to fight for him. Let me know what you think. Do you think he's just grasping at straws here, or does he really believe he's the genius in the room here?
So, Mr. Leon, your basic argument with your attorneys right now is that you want them to file a motion to dismiss your cases for failure to bring you to preliminary hearing within 14 days, correct?
That and there are other matters, sir.
Okay. Well, that's what you started with. Let's just begin
Okay.
with, all right?
Okay.
Your attorneys both know the law. Now, you've noted the statute, 222902, okay? But they also know the law. State versus Weigel, the Kansas Supreme Court ruled in 1980, quote, the time limitations in 222902 are directory and an inconsequential delay beyond the time specified for holding a preliminary hearing will not justify a dismissal. That is the law in the state of Kansas. It has been the law since 1980. It has not changed. And so your attorneys are aware of that, as is the court and the prosecutor. They do not have an obligation to file frivolous motions. And so your argument with them is that they won't do what you direct them to do, and that is not their responsibility. I explained this to you before. How an attorney handles a case, the strategy is their decision, not yours. You have input, they will listen to you, they will incorporate your thoughts, but they will do what they believe is in your best interest under the law. They are not there to do what you tell them to do. Rather, they're there to represent you zealously and as advocates within the ethical boundaries that are set there. That's the rule. So
But
you can sure tell them, I would like you to file this motion because I think it's a violation. And they would say, well, we understand you read it that way, but it's already been in front of the Kansas Supreme Court and they disagree with you. And that's the highest authority in this state. So,
but Your Honor, State versus Fink says that I have this. Hold on.
Yet I'm telling you, Mr. Allen, I'm not going to have a legal debate with you, okay? I'm telling you, I gave you the case citation. It is not the only Kansas Supreme Court case that is ruled on this issue. It is directory, not mandatory.
I understand that, sir. I've been up here for 150 days without a preliminary hearing or any type of court proceeding. That's a clear abuse of power.
Well, that's a different argument, and we're not going to, I told you we weren't going to get into that. We're here to talk about whether I'm going to let your attorneys withdraw or not, okay? But I wanted to give you at least the law to explain why they don't do everything you ask them to do.
Your Honor, that doesn't tell me anything about the procedural timeline error, though, that I've been asking them to represent me on. The procedural timeline error does say, Your Honor, that an abusive process cannot be done. I've been up here for 150 days, and I've asked my clients to please represent me in this, or not my clients, my attorneys to please represent me in this matter, and they have not done it. And they can't give me a reason. They can't give me a KSA. They can't give me any of that. And it also says, Your Honor, that I am entitled to being into a preliminary hearing or an arraignment within 10 days. I've been up here for 150. This is an abusive process.
Okay. I've listened to this before. This is what we're here for today, is your attorney's request to withdraw. Here's what the court's going to hold. You can keep filing ethical complaints on them. You can keep doing whatever, all of these pro se filings. I mean, you have a lot of time on your hands up in jail. So I'm not in any way telling you that you're prohibited from doing that. But they will control the strategy and the procedure in the representation of you. And here's the bottom line, Mr. Leon. I could appoint every attorney in the state, and they're going to have the same problem with you that these two attorneys do. That's the criteria I have to look at. Okay. If you don't like it, go hire your own lawyer. Okay. That's your choice.
Yeah, the judge knows exactly what this guy's trying to pull here, and it's just not working. He tries to lean on state versus Fink, as if it's some magic key to freedom here, but it doesn't override Supreme Court precedent. He's been in custody for 150 days without a preliminary hearing, but there's a reason for that. Serious felony cases often take months to build because of the evidence review, witness prep, and scheduling stuff, so when you're facing decades in prison for causing the death of a child in your care, you're not exactly a top priority for a speedy release. And he's also acting like the system owes him a fast pass to freedom here. But in reality, he should be using this time to work with his attorneys instead of fighting them. Public defenders are one of the most important tools in our legal system. They give people without resources a fighting chance. And here we've got a perfect example of someone who doesn't respect that at all. The court's patience isn't infinite, and the more he pushes, the closer he gets to burning every bridge he has left. I mean, this is what happens when arrogance outweighs strategy, right? Do you guys think he even understands how bad this is for him? Or is he too focused on being right to see it?
But if you can't hire a lawyer and you apply to the court, you're going to live with and deal with the competent and qualified lawyers that the court appoints for you. That's the law. All right.
Okay, sir. So
learn to live with it and learn to cooperate with them, because I'm not going to let them withdraw, because if I do, the next lawyer I appoint, I'm going to have the same argument. And here's the other thing, Mr. Leon. Your main argument is, Judge, I've been up here 150 days. I want my day in court. If I appoint a new lawyer, they're going to have to review all of the discovery in this case. They're going to have to interview witnesses. They're going to have to communicate with the prosecutor. They're going to have to visit with you. That takes time. And that you're not the only client they have. So that time is longer. So the very thing you're complaining about, if I grant the request that they're making on your behalf today, only increases that very time standard. The very key problem you're talking about. It's counterproductive.
I understand that. I'm not asking that. I'm not asking them. No,
I'm done. I am denying the motion to withdraw at this time.
Will you go on the procedural timeline error?
Okay. Jailer?
Yes, sir.
Put him on mute. I'm not going to have him interrupt me anymore. Thank you. Counsel, I just wanted to express to you that I appreciate the dilemma you have. It's not the first time you have gone through something like this. I'm denying your motions at this time for the reasons I recited. Number one, any other lawyer I appoint is going to have the exact same problem. I'm just going to keep repeating it. And number two, if I appoint new counsel, it's going to further delay the hearing, and we already have a preliminary hearing scheduled. And I'm not going to delay it another 100 days or 150 while a new attorney gets up to speed on the case. This defendant's complaining that he wants to get into court. We're going to give him that because it's scheduled, and we're going to go forward with it as scheduled. Understood?
Yes, sir.
Yes, sure.
Very good. Okay. Anything else that you need to address with the court today?
No, you're understanding.
Very good. All right. We are scheduled for preliminary. When is that again?
Next week.
Next
Wednesday,
week.
The 14th, 13th. It's the 13th.
Yeah, I knew it was coming up. I knew it was next week sometime. Let me look here. Yeah, we're scheduled for an all-day preliminary next week, Wednesday, a week from today. So since Mr. Leon's main complaint is, I want to get my preliminary, we're just going to get it a week from today. And if we hire or if we appoint new counsel, it would be delayed probably well into January or February next year with the holidays and the scheduling problems. So we will give him what he wants. I will expect that you will visit with Mr. Leon about his conduct in the courtroom. In other words, that he is not to interrupt either the judge or witnesses, that he is to listen to the evidence, that if he needs a recess to visit with you, the court will accommodate that and allow you to go into chamber or into the conference room to do that. I know he's listening to this, and I'm hoping he's paying attention, because I will not tolerate the kind of conduct that we had exhibited today, where he continually interrupts and continues to repeat the same arguments. So He's going to get a preliminary hearing as he desires, and it is a week from today. And with that, we will be adjourned.
Thank you, Your
Thank
Honor.
you, Judge.
Thank
Thank
you.
you.
Evan.
So yeah, I don't know why this guy's complaining. My guess is he's just reaching and stalling because he doesn't want to go to prison. And honestly, prison would probably be better for him than county jail. Prisons usually have better living conditions, more access to programs, and fewer lockdowns. I mean, he's also facing an unthinkable charge involving the tragic loss of his 5-month-old daughter while she was in his care. And prosecutors say dangerous substances were found in her system. I mean, that's just not something you walk away from. At this point, you don't get luxury of complaining. You take whatever's coming your way. And if this case was up to me, someone like this would never see the light of day again. So let me know what you guys think. Do you think this dude was just reaching for any delay he could get here? Or does he actually believe his own attorneys are betraying him? Thank you so much for watching, guys. I really appreciate you. Make sure to like and subscribe, and I will see you guys in the next one. Take care.